HorizonTV, the beacon for the nation. This program is suitable for general viewing.
Assalamu alaikum wa rahmatullahi wa barakatuh. Exactly 16 minutes past 8 o'clock. My name is Feisal Kassim, and let's cut the introduction. Let's talk about something that has been making headlines both on digital media and on mainstream media, something that has got the Muslim community agitated and angry. And if anything, some people, some of us feel that, you know what, we've been trampled upon. We have been denied our right to fully practice what is expected of us for as far as Islamic Shariah or Islamic law is concerned, not mentioning that it is also enshrined in the Constitution for as far as personal status under Article 27, the laws are here they're going to tell me about, of the Qadis Code is concerned. Without further ado, let's jump right in. Joining me tonight to discuss the recent ruling from the Supreme Court that actually upheld the ruling from the Court of Appeal that a child born out of wedlock will be allowed to inherit. That is basically the foundation of all this conversation tonight, and we're going to look at very many angles. What exactly does it mean if you juxtapose it against the rights of Muslims in this country? And more than anything, what will it mean to you, the Monanchi outside there, to all those cases that have been ruled and have been closed behind that? What will that mean? And of course, I cannot say all that. I am just but a facilitator. You know, the first lesson we were taught in media is that we are experts of nothing. You know, all you do is just facilitation, and that's why we've brought them here, the expert themselves. Very far end is our very lovely sister Wambui Kabage. Assalamu alaikum wa rahmatullahi wa barakatuh.
Wa alaikum salam wa rahmatullahi wa barakatuh.
Thank you so much for making time for us. It's always a pleasure.
Thank you for having me.
And of course, the gentleman looking all the way sharp, Yusuf Swaleh, advocate of the High Court. Karibu sana. Assalamu alaikum, brother.
Wa alaikum salam wa rahmatullahi wa barakatuh.
Lady and gentleman, karibuni sana. Both advocates, I'm seeing constitution files, no case here, no prosecutor, no defense. But simply just trying to separate the wheat from the chaff. I'd like to start with, let's start with Wambui Kabage. What do you make of the recent upholding of the ruling from the Court of Appeal by the Supreme Court recently, on the 30th of June to be precise, about the matter? What do you make out of it?
Okay. Bismillah. I think we have a case here where, unfortunately, I think for me, when I first looked at this case, there's a lot of emotion involved. There's a lot of feeling that you know, tumedhulumiwa, you know, as Muslims. There's an erosion of the Islamic law. I think first and foremost, just because I'm an educator, the first thing is a lot of people have not read this case. So it's important to understand what we're working with, right? So if you don't mind, just a little breakdown of facts, very summary, right? So we have a situation where a Muslim brother passed away. And he had married one wife and had children with her, 4 of them, right? And then he proceeded to cohabit with another woman and had children with her, and then married her under Islamic law, and she converted to Islam. So essentially, you're dealing with a person currently right now who is a Muslim with Muslim children. But her initial relationship was not, I guess you'd call it, that's why the children are illegitimate.
Those are within the legal purview.
Right, they were not married, the children did not come into existence under the frame of Islamic law, meaning they're illegitimate children, right? Then you have another one who came in. Now this woman, it's a very interesting story, is that she cohabited with this gentleman and had one child. But she got married, right, under Islamic law, and allegedly converted as well, and then swiftly gave birth to a child, right? But we know that under the situation, obviously, a child conceived, not necessarily given birth, is illegitimate. But her case is very interesting because she actually was already married to somebody else who deserted her for 7 years. So it's a question of, and this is what the court has also said, she's not really considered a wife, because if you're already married under civil law, then you proceed to marry somebody else under Islamic law. As a woman, you cannot do that, right? So it's not a valid marriage. Yeah. So in that context, the only person that the law, the courts are looking at in her case is her child, who now, of course, because even in secular law, that's an illegitimate child. It's not a child married, born of a legitimate marriage, right? So essentially we're dealing with 1, 2, 3, 4, 5 illegitimate children. However, with the second woman, they removed one of the children, something to do with the birth certificate, something to do with the child not being born or being of the father. So you're dealing with a number of illegitimate children, and it's also important for me at this point to humanize these people, okay? And I'll tell you why. Because we're dealing as a community with a very sensitive matter. You're dealing with minors as well, okay? And so we're saying we are, yes, blacklisting it in terms of the Quran says, the Quran says, the Quran says, but at the end of the day, we also have to understand that these are humans behind this. So I think from the onset, what I have felt about the community is a complete lack of humanization of these people who are actually Muslims. Okay, so let's begin there, right? We're dealing with our Muslim brothers and sisters, right? The second issue is the first matter initiated by the appellant, now the legitimate wife, okay, and her children started in the Qadi court. The second went to the High Court. And then the third, what happened was now the woman with the Qadi discovered this High Court matter and joined in. Right? And now the third woman said, oi, I'm part of this as well, and joined in. So then the court decided, we're not going to hear the Qadi court, we're going to consolidate everything into the High Court. So now you see a very interesting situation. The Qadi court has been deprived of the autonomy or the right to make a decision under Islamic law, and the matter has gone straight to the High Court.
Indulge me on this one. Indulge me on this one. To my understanding, again, not a lot, but to my understanding, for as long as you have submitted yourself to the Qadi's court, regardless, even if your case goes, for example, to the High Court, it's important. Of course, they have the independence as the jurists to make the decision, but for as long as you've submitted yourself from the, to the Qadi's court, one. Two, for as long as this case has been through the Qadi's court, it's important to get the opinion from the Qadis even as making that judgment. Is that?
So it's an interesting situation, and this I will fault legislation, right? We've left a bit of a lacuna. We've left a bit of an opening, whereby there is a section, right? And it is Section 65 of the Civil Procedure Act, read together with Section 87.
Of the same act?
Yes, the Civil Procedure Act, where there is this opportunity for a matter that has been heard and determined in the Qadi court. Now, if it rises up into the High Court, there shall be assessors appointed. Now, the assessor is either the chief Qadi or 2 Qadis. But you see, this is an interesting conversation. In this situation, there was no order or decree from the Qadi court. The High Court, what it did was, it just pushed everything. It said, oh, wait, this is too many things happening. We must consolidate, and we're consolidating it in the High Court.
Deal with it as one case.
Correct. So now you see, it's not an appeal, right? Because the law says appeals, right? What it is, it's we've been shoved into the High Court. So now the question comes in, is there a mandated law that allows us to say the Qadis can now come in and assist with Sharia, Islamic law?
We'll get to that, but again, I have another spanner to throw in the works that I'd like you to think about, is that, is there a way that you can say, wait, hang on, wait a minute, this whole thing, these people have submitted themselves to the Qadi's court, can we just restart this all over again? Think about it. Yusuf, let me bring you into this conversation. First of all, what do you make out of this whole situation in this case? And what exactly does it mean, given your experience as an advocate and the cases you've handled, of course, having interacted so much with the Qadi's court?
for me, it's quite an unfortunate turn of events, because in as much as the decision is personal, the decisions will be able to bind upon the practice of Sharia in the country. And this particular concept, I look at it from a point of a fight against the right to be able to practice your religion. If you look at the judgment that was delivered, to me, in my personal opinion, is a personal and one-sided argument about the interpretation of the law. Because from where I sit, the same constitution under Article 32 of the constitution indicate that every other person has a right to religion.
One-sided which side? Just to be clear.
One-sided in the...
How many sides do we have? And which side are you talking about?
No, what I mean is
yes.
The judgment that was delivered by the Supreme Court was one-sided in the sense that it did not look at other sections of the constitution, which sections would have arrived at a decision that a child that is born out of wedlock should not be able to inherit according to Islamic law. Because from the context of the same constitution that they are using to be able to arrive at the decision that they've come up with, Article 32 of the constitution is very clear that every other person has a right to be able to practice their religion. If you look at the architecture of inheritance and how Sharia law comes into practice, Section 2.3 of the Law of Succession Act is very clear that every other person who passes on after 1991, and that particular person died a Muslim, then the law that should be able to apply is Sharia law.
Whether they've submitted or not.
Yes. And in terms of the question that you asked my colleague, the issue here is this. There are forums. There are a number of forums that are available to a Muslim. You can either go to the Qadhi's court or you can go to the High Court. But the most important thread, and which is very important and which has been disregarded by this particular appellate's courts, is that wherever the forum, the substantive law that is to be applied is Sharia. If you look at the interpretations that they make, they veer from the same law, which says that for every other, in terms now of inheritance, because we are talking about inheritance, Qadhi's court has a number of jurisdiction in terms of personal status, marriage, divorce, and inheritance. But now specifically to the issue of inheritance, Section 2.3 says that the law to be applied is Islamic law. In this particular context that we are having this conversation, it is not a doubt that the person who passed on, the subject matter, the deceased, was a Muslim. The same law says that what law is to apply? Sharia law. But then again, we are subjected to aspects of the constitution which are one-sided, which are propounded towards an argument towards that, the fact that a child born out of a marriage, the issue of illegitimacy is not applicable, or rather it is discriminatory. The same constitution that our courts have used to be able to say that that is discriminatory, the same provisions in that particular constitution can be able to apply to be able to say that follow Qadhi's court, or rather follow Sharia law, and it will lead you to the fact that, you know,
it's one-sided.
Yes.
And I get it 100%. Again, and then so I'm going to come back to you and say, I don't know where the advocates in this case were to until for this ruling to get where it got and to come out the way it came, right? But again, we're here now already. And I'm going to go back to my question. So is there a way, I know it's already at the Supreme Court, this is the apex of the court, right? But is there a way that we can say, hey, hang on, we didn't follow the right procedure, even from the beginning. So can we start this thing all over fresh? Even if you're not going to start afresh, then we can pick it up from this level for a review, but again, this time with the assessors, just as you clearly pointed out earlier on.
Okay, even before we get there, I think my reading of the case, let's begin here, is, and as counsel rightly pointed out, the law that is to apply is Islamic law. Interestingly enough, in the decision, the courts did say, this is a Muslim and Islamic law applies. And that's why at the end of the decision, they've sent the people back to the High Court for distribution. But they've said, clearly, it is Islamic law that must apply. Something very glaring about this case is that if you look at the questions that they've asked about Islamic law, they've come to a conclusion. Please, let me just, a question, let me just read something for you. Okay? They have said, okay, they've posed a question here regarding a deceased Muslim parent. Okay, they have said, Okay. Such children may be excluded from benefiting from the estate of a deceased Muslim parent. And they are so the court says they've been invited to consider whether such exclusion, though grounded in Muslim law, is compatible with the Constitution. Then they go on and talk and talk and talk and talk. Can I point something very interesting about this case? They've actually not quoted any Quran, any hadith, anything that supports what they've just said. I'll tell you as a lawyer, that's an absurdity.
It is.
Because you cannot state, I'll give you an example. I take you and I charge you with a criminal offense. I say you've stolen. And then the police provide a charge sheet. And they don't state which section that you have stolen under. Any law student, first-year law student, will tell you that's something called a defective charge sheet. How can you discuss Islamic law without telling us at all in this entire judgment what section of law under the Quran
you applied,
or Hadith or Sunnah are you talking about? State exactly the wording that excludes a child born out of wedlock from benefiting, not inheriting, benefiting from the estate of a Muslim parent.
Total different ballgame.
Note, they say Muslim parent. You realize that's a lie. That's a falsity, that's a fallacy. A Muslim father. A child born out of wedlock can inherit from a Muslim mother. You understand? That's
100%.
Sharia, the distinction.
Yeah.
Right? And furthermore, if there was a wasiya, the father, wasiya is a will, the father of an illegitimate child has the right to give a third of that estate to anyone, including an illegitimate child. So on the face of this, they don't even have the law right. They have misunderstood, misinterpreted, and falsely stated what the law is in Sharia. So what do we do with that? I would argue that's the biggest mistake in this case. The hugest error that the apex court has no, actually this is hearsay. You understand? Because as long as you have not quoted which law you're talking about, you're saying Muslims, it's like muliingia baraza, mukasema, Waislamu, hawafanyang, thank you, stories ajabu, rajaba. So it's like, my gosh, maajabu.
Oh my goodness.
You know what I mean?
Yeah.
This is, for me, the most glaring problem with this. You're saying you have a problem. Muslims do not respect the Constitution because these children out of wedlock don't benefit from a state. I'm sorry, that's not true. That's actually a complete falsity. False, false, false. So me from the beginning, if I was a lawyer going on review, I'd be like, my friends, what, Haro, what is this? You've talked about European court. You've talked about the European, the European community, the judgments there. They've talked about Botswana. They've talked about the African Union. They've gone around the world. But they have not talked about the Islamic law to which you are judging, to which you are ascertaining that we don't respect the Constitution. But you don't even know which section you're referring to, which law you're referring to.
That's crazy.
I think that is the most glaring problem we're facing at this point.
We'll get to exactly how that, what we do, where do we go from now. But again, Yusuf, again, just coming back to you.
No.
With this ruling, how it is, no matter how absurd it is, how it's sickening.
It is.
Right? Because I cannot imagine the havoc and the mess it may cause within the community. From your experience, I'd like to see it from your perspective. What do you foresee in the community once this ruling is upheld the way it is and implemented?
So I'll start with the complication in terms of what has arisen from the ruling.
Please.
And this goes to specifically Article 163 of the Constitution. You'll allow me to read it because it is very important.
Sure.
So Article 163 of the Constitution says that all courts, other than the Supreme Court, are bound by the decision of the Supreme Court. So basically that in very simple terms means whatever decision that has been made by the Supreme Court will be able to bind every other court. In the context of Islamic practice, means the Qadhi's court is affected by the decision of this particular Supreme Court. The Supreme Court has already said that a child that is born out of wedlock should be able to inherit. That is contrary to Sharia. The High Court will be bound by that particular decision. And the other appellate mechanism, for example,
if it sails through as is without being challenged or reviewed?
Yes.
Okay.
But as at now, it has not been challenged. No review application has been done. So as at now, whatever decision that has been made by the Supreme Court now becomes the law. So as we speak right now, it is the law that a child that is born out of wedlock in the context of Islam can be able to inherit. There are a number of matters that have been filed in the Qadhi's Court, in the High Court. It will be able to mean that it will be okay for you to be able to sire a child out of marriage. There will be no repercussions in terms of what will be able to happen during inheritance. And this is just but one of the unfortunate guns that has been directed towards the practice of Sharia. There are other things that have been happening. For example, nowadays, you can just, you can contract an Islamic marriage, okay? And if you have an issue, you want to opt out of a marriage, and someone else, you file the case, for example, in the Qadhi's Court, and your spouse can just come and say, yes, I profess the Islamic faith, but I do not submit to the jurisdiction of the Qadhi's Court. And that is enough to be able to not to hear the matter. Remember, for example, in that particular context, maybe the nikah that you would have done, ordinarily you would have done it at the Qadhi's Court. Here is the same person who's saying he's not submitting to the jurisdiction of the Qadhi's Court, yet that Qadhi's Court is the one that officiated the marriage. So I'm looking at it from a point of very unfortunate practice that will be able to happen and will be able to affect the Muslim Ummah.
That is sickening. I mean, I can imagine how many cases will be reopened, how many reviews will be applied, especially for those who are just waiting and bailing for an opportunity. They're waiting for an opportunity to come in. Guys, we're due for a fast break. I'm already getting calls and texts right here from the audience. It is really an emotive matter. It has, oh my goodness, wow. Anyway, let's just hold on it. Let's go for a break. And then once we are back after this very short break, we're going to sample very few of your questions because, I mean, I still have a full list here, guys. We'll see how we can integrate some of those, inshallah, and see how we can try to get the best way forward and what especially you back there at home can do to help the situation. Please keep it live, Real Talk.
HorizonTV, the beacon for the nation. Verse of the day.
أعوذ بالله من الشيطان الرجيم بسم الله الرحمن الرحيم
وعباد الرحمن الذين يمشون على الأرض هونا وإذا خاطبهم الجاهلون قالوا سلاما والذين يبيتون لربهم سجدا وقياما والذين يقولون ربنا اصرف عنا عذاب جهنم إن عذابها كان غراما إنها ساءت مستقرا ومقاما.
Are you looking to stay informed about the amazing stories within the Muslim community? Do you want to hear inspiring stories and insightful discussions about faith, culture, and current events? Tune in to the Muslim Insight, your weekly news updates where we tell you stories that matter to you. The Muslim Insight, informing, inspiring, every Friday from 8 a.m. with me, Zamzam Ahmed.
أعوذ بالله من الشيطان الرجيم يا أيها الذين آمنوا إذا نودي للصلاة من يوم الجمعة فاسعوا إلى ذكر الله وذروا البيع ذلكم خير لكم إن كنتم تعلمون.
Enyi mlioamini, munapoitwa kuhudhuria swala ya Ijumaa, fanyeni haraka kuikimbilia, muache biashara zenu, hilo ni bora ikiwa mwelewa.
Isikilizeni kwa umakinifu khutba ya Ijumaa
ili uzidi kujenga imani yako na kupata faida nyingi ya siku hii.
Coming to you every Friday from Jamia Mosque, Nairobi.
Live on HorizonTV.
Horizon TV, the beacon for the nation.
Assalamu alaikum warahmatullahi wabarakatuh. Welcome back, and thank you so much for keeping it live, real talk. And I'm just going to jump straight into, you have realized I'm not going to be selfish because you have, what, 18 minutes to go, and we're going to try and see and sample some of your questions. So a viewer, Sadiq, all the way from Turkey, is asking, and I'm going to ask you, our boy. So for a Muslim man out there who has children out of wedlock at the moment, what should they do, A, to ensure that his estate doesn't fall into a similar tussle, while B, ensuring does not break the law of the land?
Yeah, so I mean, as a Muslim, we understand that we've been told by the Prophet ﷺ that we must write our wills, we must do our wasiyah, which is basically you have to articulate what it is you want to happen upon your death. And our country really respects that. And I mean, I know some of us postulated if this gentleman had a will and had actually applied it and said, look, I recognize these children, I take responsibility for them, and I will put them in the 1/3 part of the will that allows me to distribute the rest of my wealth, that specific 1/3, in the way that I wish, and put the children in there. Nobody could have challenged that because you're providing, you're giving a provision. Because one of the most important things you need to remember in this case, the problem was this. Their problem was there was no provision provided at all. They're going to be kicked out with nothing. So if you give provision, now questioning that provision is a whole nother ballgame. So I would recommend every Muslim to have a will.
Wow. Wow.
There are also other options that can also be employed. One of the options is something called a gift, or in the Islamic concept, hiba. You can be able to gift a property. For example, you are quite aware, acutely aware, that you have a child born out of wedlock. One of the options is to be able to do a gift and gift this particular child. It is
while you're still alive.
Yes, it is allowed in our Islamic concept. There's also the other option of something that is brewing in other jurisdictions in terms of trust. You can also incorporate a trust that will be able to accommodate these children who ordinarily, in the concept of succession, normal succession, they are not entitled to. So there are many options.
Okay, interesting. Another question from a viewer, he's asking, does the precedence apply to backwards previous cases? I think we mentioned about this. Will we see all administration cases or suits being reviewed claiming that the new ruling proves that their children missed out on their deserved inheritance? Is it a possibility?
I will believe so, but in terms of, it will be able to apply to those particular matters that are within the timelines for appeals, within the timelines for review. But trust me, anticipate those kind of applications that will be able to flood our courts.
Wow, interesting. Wambui, we have 15 minutes. Moving forward, what then do we do? What are the options on the table to see sanity, or rather to protect the Sharia law as enshrined in the Constitution? And of course addressing some of these lacunas or some of these gaps that we have seen in the recent judgment. What can we do? What can be done by all the parties? Talk of the Muslim leaders, talk of the Muslim professionals, the lawyers, the media practitioners and all that. and talk of the imams.
Yeah.
What can be done? What can we do?
Yeah, I mean, first and foremost, there's still hope in this case. Let's begin from there. Because one of the things that they did say, Islamic law still applies, which means even when you go back to the High Court, I would hope what would happen is we would get lawyers that would insist on assessors, people, or even at the very least experts who are capable of dividing their state in a manner that is Islamic. Now, under Islamic law, there has been in other jurisdictions a conversation about how do the courts recognize that when there's a manifest injustice, how can you apply that 1/3 rule, right? So even if not all is lost, they can go back, they can get a qadi, they can get the division done in accordance to Islam and just recognize, and it's important to point out, this judgment simply said that these kids are beneficiaries. They did not state that they are heirs, number one. Neither did they apportion how much was to be given to these children. So there's still hope. We can still apply this ruling and try and make it an Islamic outcome in the High Court. That is possible. That's number one.
But the danger is the moment you leave it blanketly as it is, I think it will now depend with the jurists who will be sitting on that bench.
There is, it's true. And I'm just taking worst case scenario. If a review is not successful, they've been told as of utmost urgency, they must go back to the High Court and do a distribution. So that's stage one. There's another one where we do a review based on the fact that this case has very many problems with it. And, but it's a very narrow scope. Review is a very problematic situation all over the world. Challenging a Supreme Court decision requires a lot of thought, a lot of reflection, and a lot of case law from different parts of the world. So we need to be aware this is not going to be an easy journey, okay? The next thing is, okay, first of all, let's blame ourselves. Let's begin from there. Myself, as an advocate, okay, we begin there. Because at the end of the day, like you said, this was a situation where it was coming. It has been brewing, right? And unfortunately, this lady was left in the court to represent herself. Can you imagine me as an advocate standing before 7 judges by myself doing a presentation? Yusuf, I don't know, I give you jitters, right?
Yeah,
I can't imagine what it would do to a woman who's never presented herself before a court.
Yes.
So we blame ourselves, okay? And as a ummah, we're told, do hisab before Allah subhanahu wa ta'ala does hisab on you. We have done wrong by this woman. We've done wrong by the ummah. We should have done more. And one of the things we needed to have done is recognize these loopholes in the system and created legislation that impacted and harmonized this conversation. Right? You're right. We are allowed to go to the High Court and the Court of Appeal, and the law that applies is Islamic law. But there's always this push and pull and tug. How do we as legislators or legislators that exist, how can they fix that? The next thing is civic education. Why are we not having symposiums? Why are not people sponsoring symposiums for non-Muslims, Muslims, judges, and why are we not doing this? And educating them about what Islamic law is. There's already a perception, and this is what the judgment says, that we as Muslims are barbaric. We don't comply with the constitution. That is wrong. They already assumed we would never support or give any kind of benefit to legitimate children. That's not true, right? So that means with this misinformation, lack of education amongst Muslims and non-Muslims, we need to educate ourselves. And then finally, as the legal fraternity and the judiciary, and as an ummah, we need to sponsor people to study Shariah. Okay? We need judges, we need magistrates, we need Court of Appeal judges, we need Supreme Court judges, we possibly need a CJ that is conversant in both laws. Not enough to have secular law. You must also be a Sharia expert. A long time ago, what we used to do is take a child and you sponsor that child both in secular education and Sharia education. Why are we not doing that? So we're always firefighting. Right? We need to facilitate the judiciary and especially the Qadi courts. This is an Islamic institution. We must support these institutions and ensure that Kenyans are Muslims are supporting these institutions to be the best juristic systems that exist. We don't need permission. We don't need help. We can do this as an ummah.
By ourselves.
Yes, absolutely.
Interesting. Yusuf, I'd also like just to pose the same question in you, of course, picking up from where she's left. What else do you think now we can do moving forward to see how do we bring in, let me say, sanity? Because if this thing is left to go as is right now, we're going to witness lots of insanity. So what can we do then to bring the sanity or to stabilize the sanity?
For me, first and foremost, the most important issue, and I will believe the genesis of these particular problems that we are suffering, is the understanding of Sharia. There is a misconception about Sharia. a lot of people, including ourselves, Muslims, do not understand that Sharia is a complete legal system. Our laws are marred with common law. Common law is the law of England, okay? And if you look at these particular rulings and judgments that we are aggrieved with, are basically imported from common law, not Sharia. And that is the reason why I said from the beginning, the problem is misconception. Because you see, I quoted to you the issue in terms of inheritance, and it is very clear. It's saying Sharia law should be able to be applied. My colleague also indicated about the issue of assessors. And unfortunately, the practice is, despite the fact that there is a substantive law talking about the issue of assessors, in terms of practice, these particular assessors as qadis, they are not usually called upon in the High Court to be able to sit with the High Court judges to be able to advise them on matters Sharia. You would understand, for example, in the High Court, in the Court of Appeal, in the Supreme Court, most of these particular judges are schooled in matters of common law, not Sharia. So they do not have an understanding about Sharia. That is the issue. So in terms of action plan, in terms of that aspect, I would advise that we go with civil education. It will really help. I was with my colleague, we organized a workshop of judges of the High Court, judges of the Court of Appeal. They came, we were able to take them through what Sharia is all about. There were Muslim scholars, including qadis and such like. And I've been able to see, based on that particular workshop, fruits from the High Court. Because nowadays, when you appear before the High Court here in Nairobi, these particular judges, they welcome the opportunity, and they've been now calling qadis to be able to sit with them and to be able to advise them on matters of Sharia. So I would believe it will be able, yes, assessors, it will be able to work out. Number two, the most unfortunate bit, and I am sorry, I am speaking from the point of pessimism, is that there's been a systematic sabotage in terms of Sharia. It is important to look at the history of Sharia, or rather Qadhi's Court. Most people don't understand and don't know that Qadhi's Court is the oldest court in the land. It actually existed before colonialism.
Yeah.
When the British colonialists came to this particular country, they found the Qadhi's Court system working, and they were able to incorporate it into the system. They did not do away with it. In 1963, because the coastal strip was part of the
Sultanate of Zanzibar.
What happened is there was a deliberate...
Actually, Sultanate of Oman, but it was from Zanzibar.
There was a deliberate emphasis on the British colonialist to demand that the Prime Minister then, Jomo Kenyatta, to be able to make an undertaking that if the coastal strip will cede to Kenya, then the undertaking will be the Qadhi's Court will form part of the judicial system. And the undertaking is there. It's called the Shamte Agreement. And it is that Shamte Agreement that resulted in the independence constitution that we had in 1964 that retained the issue of the Qadhi's Court. One of the most important things is that there was an understanding before this particular country came to being that the Qadhi's Court will be preserved. In 1964, it was preserved. Subsequently, when there's an amendment of the constitution, it was preserved. But now, in that particular constitution, it was saying the Qadhi's Court shall have jurisdiction to deal with matters of personal status, marriage, divorce, and inheritance. But you will note in 2010, when the new constitution was promulgated, now I am talking about the systematic sabotage, they introduced this aspect of professing to the Islamic faith. And now there is substantive attacks in terms of now, for example, children that are born out of wedlock should be able to inherit and all that. I think it is important as the Muslim Ummah, and specifically those people who are versed with law, to be able to be proactive in terms of the laws that come in. For example, right now we had a legislation in terms of children. There was a concept about the community, an Islamic concept that was introduced. Unfortunately, the Muslim Ummah were not consulted in terms of drafting the constitution. Not the constitution, sorry, that particular legislation. Yeah. The problem is, whenever there is usually legislation in terms of matters affecting Muslims, Muslims are not involved, or they are not incorporated into coming up with laws that will be able to apply to them. So for me, the second thing that is very important is we need to be very proactive. We need to be very responsible in terms of making sure that the legislations that are passed, we have a say in terms of them. There is the Qadhi's Court that is now being amended. And unfortunately, if we are not careful, again, this particular legislation will be drafted by someone who does not understand Sharia, and unfortunately will be subject to the same law So it is very important that we participate in this legislative process.
Talk about being proactive. I just want to throw again another spanner into the works. A number of these issues that we are facing talk of either, is it personal status issue, or is it issues to do with children, you know, whether like who deserves a custody and whatnot. These are some of the rampant issues that always come. And the problems always come, the tussle between the ruling of the Qadhi's court and the appellate system, whether the High Court or the Court of Appeal. And it got me thinking, what is stopping us from trying to expand the Qadhi's court at the High Court level, or even at the Court of Appeal level? What is really stopping us?
There was a proposal. There was a proposal to do something like that, but that was kind of shut down. So it's literally just the idea that we have not legislated that, have not been able to expand the Qadhi courts. It wasn't that there were no suggestions to that effect, but they were shut down. And I think it's really, at the end of the day, we are our own enemies, you know, because we need to lobby at the extent of saying, look, it doesn't make any sense for you to say that there's a system that doesn't have an appellate structure. You're saying we are preserving the Islamic law, and we're allowed to go all the way. So why don't you create a system that allows the appellate process? It's going to take a lot of lobbying. It's going to take legislation. It's not just as simple as that. And unfortunately, we need to do our work as an ummah, as a community, and say it is a logical progression that makes sense.
Which brings me to the point. So yes, you did it once. It was shut down. What are you doing next, and what do you want from me to make it work? And from the community?
Yeah,
the viewers are out there, you can face this comment.
Sure. I mean, quite frankly, we can't even talk about a High Court and a Court of Appeal because we're not supporting the current court that we have. So at the end of the day, when you say you want to go all the way to the appeal court, we've not even successfully supported the Qadhi courts.
So number one, you support
we
the Qadhi
must support the Qadhi courts. Second of all, I think it's very important that we consolidate our rulings and judgments together to allow the judges in the High Court and the Court of Appeal. This is our biggest mistake. We feel at some point that the High Court and the Court of Appeal are our enemies. I can assure you, and I know, Yusuf, when we went to the symposium, a lot of these judges, a lot of these, they want to understand, because for them, they're like, we just don't know. It's as simple as that. We're not sabotaging you. We don't know. So we need to be able to compile, for example, an Islamic law journal. Have we done that? For us to say that there's a consolidated way of thinking that we are doing as a community. Who is sponsoring that? We're happy to sponsor hospitals, happy to sponsor masjids. Do we understand that the ummah is bigger than that, is more than that? We need people to say, right, we need to support the legislative system in Kenya that God has given us, that has not given many minority countries in Africa. We are unique. So we need to put money where our mouth is. Create a law journal that our lawyers, our judges can say, this is the body that we need to reference when we're making matters, Islamic law, work. Once we have that working, then we can talk about a High Court and a Court of Appeal.
100%. Yusuf, moving forward, what would you want from the Muslim community to try and see the general legal system and justice system within the Muslim community is at least upheld to the standard that it deserves?
For one, like I indicated, we need to be very proactive in terms of the legislative processes that they come up with. But
again, you also need to understand a number. I may be in the loop because I'm in the whole information ecosystem. But again, the people back at home, do you have channels to, what do you call it, sort of trickle down this information to them?
And that is why civil education comes in terms of preaching the same. You know, most of us even don't understand the Sharia aspect of it. We start by ourselves. We start by projecting the issues of Sharia and the Qadhi's court and the importance of the Qadhi's court to the Ummah, which will propagate to other avenues that are very important in terms of the legislative process, in terms of the judiciary. We need to have our brothers and sisters also apply to be in the judiciary so that they're in that particular position to be able to interpret these particular aspects of Sharia in the proper manner. Yes. The other aspect that I think it is important that we need to look at is conversations about an appeal mechanism within the Qadhi's court. That will be able to resolve a lot of problems because, again, we subject ourselves to systems that are not versed with Sharia. And then we end up with outcomes that we'll be able to cry about. So there's that option of also looking into mechanisms to be able to have an appellate mechanism within ourselves, within the Qadhi's court, to be able to assist.
I'm going to give you 30 seconds to give your closing remarks, starting with you, Wambui.
For me, I'd just like to point out that we're very blessed in Kenya. We have a system that allows us to practice our faith, not just in your house, but generally across the board. I think it's important, it's about time that we begin to stop complaining about the Qadhi courts and start supporting the Qadhi courts. When we have a matter that's a matter that relates to us and our lives, we must go to these courts. We must support them. And then the people who have capacity and financial capacity must recognize that they have to support this institution. We have to support this institution. But most importantly, we need to become knowledgeable about Sharia and the value of it and the importance of it and the richness of it. It has such incredible jurisprudence, such incredible case law. It is a system of 1,400 years. It is far more superior than the common law system. And we need to begin to be proud of this system and the intellectual capacity that it brings and enhances to our lives. That's what I would say.
Wow, thank you. Yusuf.
For me, it is important, and it should be able to down on every other Muslim community, that it is important that law binds us and whatever decisions that are given binds us. And if it is unfortunate, then we bear the brunt of the unfortunate aspect of it. We've made tremendous steps in terms of propagating for the practice of Sharia. We've made tremendous steps in terms of having a Qadhi's court system. Our forefathers really fought for the same in terms of us having the Qadhi's court. Our forefathers fought so that we could be able to have an amendment of the Law of Succession Act. And that's the reason why today we talk about the aspect of Sharia. So many people have made tremendous steps in terms of introducing the aspects of Islamic banking, finance, and you have legislation trickling down to be able to accommodate Islamic corporate bodies and all that. I would insist that we become proactive and we continue to do that. We continue to become custodians of our own laws, because if we sleep and then we will wake up when the system has turned against us, and then we'll be here lamenting without any solution.
Wow, thank you so much, ladies and gentlemen. Amazing conversation. Thank you so much. I mean, it got me thinking a lot. It really got me thinking a lot. What I got from Yusuf, we need to be proactive. What message that really screamed from Wambui Kabage is all about support, and information. And I'm challenged, honestly speaking. And what I'm going to do with that challenge, and this is now to the viewer, what I'm going to do with that challenge is that 3-4 years ago, I conceptualized a whole TV show, a whole program called Hakiyatu, which is going to be a conversation, interviewing lawyers and challenging myself and all of us to know the laws that are governing us, both Islamically and living in this land, secular land. So that is the challenge that I'm planning to take up. I'm willing to go back, revise that show, and bring it back. And I promise you, inshallah, if Allah gives us the will and the time, in 3 to 4 months' time, very max, you will see that show, either digitally or on TV, called Hakiyatu. Are you guys willing to come on board and take part in that show?
Any day, anytime.
Just invite us.
Thank you so much. That is me. I'm a media practitioner, and I've taken up the challenge. And that is exactly what I'm going to do, to try and better the situation. What about you? You're another lawyer back at home there. You are a doctor. You are a sister. You're a businessman, entrepreneur. You have millions and billions in your account. What are you willing to do to try and change the situation? My name is Feisal Kassim, and this has been the Live Real Talk. See you next week, same place, same time. Assalamu alaikum wa rahmatullahi wa barakatuh.
Horizon TV, the beacon for the nation.
Are you looking to stay informed about the amazing stories within the Muslim